Good afternoon, and thanks for joining us for today's webinar, Discovery Challenges, GDPR Legal Tensions. My name is Randi-Lynn Smallheer, and I'm a content manager on the civil litigation team at LexisNexis. With me is my colleague Caren Silverman, a subject matter advisor for litigation at LexisNexis. We have today's presenters, Sean Gorman and Daisy Puente, here with us today to discuss discovery challenges associated with the GDPR. U.S. courts are increasingly reluctant to defer to the GDPR's protections of EU residents' personal data when those protections collide with U.S. discovery obligations. Today, Sean and Daisy will provide us with an overview of the GDPR, a discussion of recent U.S. court decisions addressing the GDPR in the context of discovery obligations in U.S. litigation, and suggestions for complying with both the GDPR and U.S. discovery obligations. Sean is a partner at Bracewell, representing clients in high-risk and high-value disputes across practice areas. Sean's practice largely focuses on commercial disputes in the areas of contracts, business torts, antitrust, and intellectual property. His expertise also extends to adversary proceedings in bankruptcy cases, mass torts, litigation arising under the U.S. Constitution, and follow-on litigation related to criminal prosecutions. He has represented plaintiffs and defendants in the energy, financial services, chemical, petrochemical, steel, communications, oil field services, medical products, software, government, accounting, construction, real estate, and manufacturing sectors. Daisy is an associate at Bracewell handling complex commercial litigation and appeals. She served as a judicial intern for the Honorable George C. Hanks, Jr. in the U.S. District Court for the Southern District of Texas, as well as for the Honorable Edith H. Jones of the U.S. Court of Appeals, Fifth Circuit. Before Sean and Daisy get started, a few housekeeping items. This webinar will run for 30 minutes. You'll see the option to submit questions in the webinar interface. Please use this area to submit any questions you have, whether about a topic covered during the webinar or a technology issue. Due to the length of today's program, we will not have time to answer questions live, but we will pass them on to Sean and Daisy to be answered by email. In the bottom left, you'll see in the resources section of the interface links posted to some additional practical guidance relevant to today's presentation. Finally, at the end of the webinar, a short survey will be displayed where you can request more information or training on resources mentioned on today's presentation. I'll now hand over the webinar to Sean and Daisy.
All right, thanks, Randi-Lynn, for that introduction. I will go ahead and start. As you mentioned, my name is Daisy Puente, and to begin, I'll give you all an overview of our presentation today. First, I'm going to start off with a discussion about the history of the GDPR and a general summary of some of its relevant provisions. As you're probably all aware, the GDPR is a complicated regulation, so this is truly going to be a very small fraction of the overall regulation. After that, Sean's going to discuss the recent U.S. court cases regarding the GDPR and provide some suggestions and best practices for complying with it while fulfilling U.S. discovery obligations. Okay, so for those of you that don't know, GDPR stands for the General Data Protection Regulation, and it is the European Union's data privacy law. Its purpose is to ensure the protection of the right to privacy guaranteed in the 1950 Charter of Fundamental Rights. It states, everyone has the right to respect for his private and family life, his home, and his correspondence. The GDPR replaced the 1995 European Data Protection Directive. That directive was passed as a way of providing privacy protection in light of quickly developing technologies, such as the invention of the Internet. Of course, advancements continued at a rapid pace, and work began on an updated, modern, and comprehensive approach on personal data protection. The result was the GDPR, which was nearly 70 pages longer than the 1995 directive. The GDPR is the self-described toughest privacy and security law in the world. It has a broad scope, strict compliance requirements, and heavy penalties. The GDPR has a global reach. It requires organizations to safeguard the privacy rights of anyone in the EU, including non-citizens and visitors. It imposes obligations on any organization that processes the personal data of EU residents, regardless of whether the data processing takes place in the EU. any organization that offers goods or services to individuals in the union, regardless of whether that organization is in the EU, and any organization that monitors the behavior of EU residents. Some important definitions for our discussions today. The GDPR defines personal data as any information that relates to an identified or identifiable individual. This includes names, job title, work email address, IP address, and document metadata. In effect, information that would generally be considered benign in U.S. litigation. The GDPR's definition of data processing includes collection, storage, retrieval, transmission, dissemination, and destruction. This is nearly every step of a document review and production. The incompatibility of these definitions with the U.S. discovery process is unsurprising when one considers that most European countries do not have much party-driven discovery and limit disclosure of evidence to what is necessary to prove or defend a case, which is, of course, very different from the broad discovery allowed under the federal rules of civil procedure. So with those definitions in mind, let's turn to some of the rules that are particularly relevant to our discussion today. Any organization processing data has to do so according to the 7 protection and accountability principles outlined in Article 5 of the GDPR. First, personal data should be processed lawfully, fairly, and in a transparent manner. Second, processing data must be done only for the legitimate purposes specified to the individual when the data was collected. Third, organizations should collect and process only as much data as absolutely necessary. Fourth, personal data must be kept accurate and up to date. Fifth, information may only be stored for as long as necessary. Sixth, processing must be done in a way that ensures appropriate security, integrity, and confidentiality. Seventh, the data controller is responsible for being able to demonstrate GDPR compliance with all of these principles. Further, when processing and transferring personal data to a non-EU state, a party must comply with the requirements of Article 6 and Chapter 5 of the GDPR. Article 6 lists the only instances in which it is legal to process personal data. The first 2 listed here, unambiguous consent and legitimate interest, are the most relevant to this discussion. Consent. Processing is allowed if the individual gives you unambiguous consent to process his or her personal data for a specific purpose. The European Data Protection Board has issued helpful guidelines on consent that are available on the European Commission's website if any of you are interested in that. Legitimate interest. Data processing is allowed if it is necessary for the purposes of a legitimate interest pursued by the organization. This provision requires a balancing test and only allows processing where such interests are not overridden by the interests or fundamental rights and freedoms of the individual. And just a quick note on that third bullet point there. Processing is allowed when it is necessary for compliance with a legal obligation. While that may sound helpful, this provision only concerns legal obligations under EU law, and it does not apply to litigants complying with U.S. discovery obligations. Chapter 5 contains specific additional rules for the transfer of personal data from the European Union to a non-EU state. Article 48 states that any judgment of a court of a third country requiring the transfer or disclosure of personal data may only be recognized or enforceable if it is based on an international agreement or authorized by another provision of the GDPR. This provision makes clear that a court order alone will not be sufficient to warrant the transfer of personal data to the U.S. Article 49 is a key provision for civil litigants in the United States. It allows for the transfer of personal data to a third country under certain circumstances. Like Article 6, this includes explicit consent and legitimate interest subject to that same balancing test I mentioned earlier. Article 49 also allows transfer if it is necessary for the establishment, exercise, or defense of legal claims. The key word there is necessary, which is likely to be defined narrowly by EU courts. It is important to keep in mind that transfer under Article 49 is allowed only if the transfer is not repetitive, concerns a limited number of data subjects, is necessary for the purposes of compelling legitimate interests pursued by the organization, which are not overridden by the interests or rights and freedoms of the individual, and the controller has provided suitable safeguards with regard to protection of personal data. So in order to ensure compliance with this regulation, the GDPR allows for potentially massive fines for violations. The maximum fine is 20 million euros or 4% of global revenue, whichever is higher. Now, of course, when the GDPR was first introduced, this was one of the most discussed aspects of it. Although there have not been any fines levied against a company that breaches the GDPR because of discovery obligations, headline-worthy fines against other corporations show the potential scale of penalties. Last year, Marriott received a $123 million fine for a major security breach. This was about 3% of Marriott's global annual revenue. That same week, British Airways received a $240 million fine for exposing payment details and personal information of 500,000 customers. This was about 1.5% of its worldwide sales. Both Marriott and British Airways are expected to be able to negotiate a reduction in these fines. However, these fines serve as a warning that the GDPR is to be taken seriously. And regulators are just getting started. The GDPR has only been in effect for 2 years, so we're still in the early days of fines and enforcement. But over the last year, we have seen an increase in the number of fines issued. As of February 2019, 9 months after the law took effect, only 91 fines have been issued. As of August 2020, there have been 347 fines issued. So with all of that in mind, I will now turn it over to Sean. Sean?
Thanks, Daisy. I'll walk us through 3 recent cases and then offer some suggestions on complying both with U.S. discovery obligations and the GDPR. So, first case is the Georgie Global Holdings case, which involved allegations of civil violations of RICO, breach of contract, and the Computer Fraud and Abuse Act. One of the defendants was a resident of Poland and who was also a U.S. citizen named Smolsky. The court noted he was subject to the jurisdiction of the court, which of course is essential for a court to be able to exercise power over a defendant. Smolsky argued he was not able to produce otherwise discoverable information because the GDPR prevented it. So the Georgie court began by quoting the principle established by the U.S. Supreme Court in the Aerospatiale case. And the principle is that generally a foreign country's statute precluding disclosure of evidence does not deprive an American court of the power to order a party subject to its jurisdiction to produce evidence, even though the act of production may violate the foreign statute. The Aerospatiale case also established the standard for determining whether the foreign statute excuses noncompliance with discovery obligations, and the standard is the balancing test in the Restatement Third of Foreign Relations Law, Section 442. 5 factors. First, the importance of the documents or information requested to the litigation. In the Smolsky case, the court found that the documents the plaintiff sought related to the defendant's alleged money laundering scheme, and that the defendant had not produced any documents addressing the issues. Therefore, the court found that there was a substantial likelihood that the documents were important to the claims, to the case. The second factor is the degree of specificity of the request. In Smolsky, the document requests were found by the court to be reasonably specific, and therefore that factor, like the first one, weighed in favor of ordering production. Third factor, whether the information originated in the U.S. The court found that these documents at issue in the Smolsky case originated in Poland, and that factor therefore weighed against production. Fourth factor, availability of alternative means of obtaining the information. In Smolsky, the individual defendant, deleted information from a company computer that would not have been protected by the GDPR. The court found, therefore, there was no alternative there are no alternative ways of obtaining the information other than from the individual defendant. Fifth factor, the extent to which noncompliance would undermine important United States interests. The Smolsky Court and courts in general consider this the most important factor. And the Smolsky Court concluded that the United States has a substantial interest in fully and fairly adjudicating matters before its courts, an interest only realized this is the quote from the court, an interest only realized if parties have access to relevant discovery. So the court found that factor weighed in favor of production. And so on the whole, all the one factor weighed in favor of production, certainly the most important factor did, and the court ordered production. The court also noted that the party resisting discovery bears the burden of showing that the GDPR bars the production of the documents. And there was some question whether Smolsky had even met that fundamental burden. Second case is In re Mercedes-Benz emission litigation, in which the district court was reviewing the magistrate judge's conclusion that Mercedes must produce information regarding current and former employees in unredacted form, and that considerations of international comity did not relieve Mercedes of that obligation. So the court again began with the concept that the party relying on the foreign law has the burden of showing that the foreign law bars production, and then moved on to the restatement comity analysis. With regard to the first factor, the court found that the evidence was directly relevant to the claim. The court noted that there was a protective order in place that allowed Mercedes to protect the names of these former employees. With regard to the second factor, the court found that the request for the names, positions, titles, and contact information was specific, seems pretty specific. Third factor, the court found that a majority of the information did originate in Germany. Fourth factor, as far as alternative means, Mercedes had offered what it called a layered approach to discovery, where it would first produce information with the names redacted, but the court rejected that approach, finding that the names were essential to the use of the data. And then fifth, the extent to which noncompliance would undermine important U.S. interests. Here, the Mercedes court found that the U.S. has an interest in maintaining the integrity of the discovery provisions of the federal rules of civil procedure. The court did consider the EU's interest in protecting its citizens' privacy, but on the whole found that the balance weighed in favor, not surprising for an American court, that the balance of those interests weighed in favor of protecting the American interests in allowing discovery. The third case is Fingen v. Zscaler, which is a patent infringement case. The defendant asserted that it could not produce its sales director's UK emails because of the GDPR. In the Fingen case, the court, with regard to the consideration of the factors, found that the witness's emails were directly relevant to the allegation. It's interesting, the defendant company ordered that it's possible that the UK residents' emails could be duplicative of U.S. Employees' emails. You know, if the employees are emailing back and forth, perhaps the same data would be in a U.S. custodian's email account. Now, there's still a GDPR issue if it is personally identifiable information of the EU resident. But nonetheless, the defendant ordered it could be duplicative. The court found, well, you know, the defendant couldn't establish that because the defendant hadn't looked at the UK resident's email account. But of course, as Daisy pointed out, even just reviewing it would have been processing under the GDPR and prohibited. Second factor, specificity. Here, The plaintiff had suggested search terms, so it was an ESI search, and the court found that the search terms were appropriately limited. Third factor, the court found that although the information was created and located in the UK, it's interesting, the court noted that it's an American company, and therefore that factor weighs in favor of production. I'm not sure that that's the right way to weigh that factor, but that's what the court found. Fourth factor, alternative means. Again, the defendant argued that the emails could be duplicative of emails not protected by the GDPR, but couldn't substantiate it because it didn't review them in accordance with the GDPR. The defendant also offered to redact personal information, but the court found that was not a substantially equivalent alternative because the information that was going to be redacted, the court found to be relevant to determining who the witness had been communicating with about the issues in the case. With regard to the final, most important factor, the court found that although the UK has an interest in protecting the privacy of its citizens, courts recognize that an interest in protecting privacy is diminished where the court has entered a protective order preventing disclosures, which was present in that case. Again, the concept of a protective order seems to be important in the court's analysis of this. And then the court compared the UK's interest in protecting the privacy of its citizens to the U.S. interest, the significant U.S. interest in protecting its patents, and on balance ordered production of the emails. Now, the court also noted a couple of interesting things. First, that in the court's view, it's not clear that the GDPR prevented disclosures because the GDPR, as Daisy pointed out, permits the production of personal data, which is essential to defending or litigating a claim. But as Daisy also pointed out, the European Data Protection Board has indicated that an order from a U.S. court isn't sufficient to satisfy that standard. The Zscaler Fenton Court also noted that the burden of showing that a foreign law bars disclosure is not met where there is no evidence that the foreign law is actually enforced. So with regard to GDPR enforcement in U.S. related to disclosure of information in U.S. litigation, there have not been any cases. And so that could be a factor that American courts take into account. Presumably there will be, and of course nobody wants to be the first one. All right, some ideas on how to both comply with U.S. discovery obligations and with the GDPR. So on the one hand, you're not subject to sanctions under Rule 37, and on the other, you're not subject to the fines, which can be massive, as Daisy talked about, under the GDPR. So one possibility is use of the permission under Article 49 of the GDPR that allows production, processing of the data, and transfer of the data if necessary for the establishment, exercise, or defense of legal claims. And so obviously a party trying to provide for production would want to establish a clear record of that, or if you're trying to resist production, show that there is no connection. It's a very high bar under the GDPR and requires a finding under EU law that there is a close and substantive connection between the data in question and the specific establishment, exercise, or defense of the legal position. The European Data Board has issued some guidelines addressing this. The second possible approach is consent. Now, as Daisy points out, there are guidelines on how to establish unambiguous consent. The difficulty with relying on consent is that an EU resident may withdraw consent to the use or production or processing or transfer of that person's personal data at any time. And if the consent is withdrawn, the data controller may not rely on any separate lawful basis. For instance, the need to use the data to establish or defend a legal claim. If the data controller has relied on consent, the data controller cannot then try to rely on a separate lawful basis for using the data. It must respect the resident's decision and not use the data. This is similar in a way, or not similar, but it calls to mind the EU right to be forgotten. And how does this come into play in litigation? If an EU resident conceivably could demand the destruction of their personal data despite the data being subject to a litigation hold, that would raise all kinds of questions in the American, under EU law. It's an absolute right. Under American litigation hold jurisprudence, that would be a serious problem, perhaps. All right, next idea is using tiered productions, kind of what Mercedes tried, but I think the way to go about it would be first offering discovery mechanisms that would not impinge on any personal information, such as asking the other side to send requests for admission or interrogatories, offering stipulations or affidavits or declarations, offering redacted information, then offering information from consenting witnesses, and then at the very end, if you have to, offering or then going to court to argue against the production of personal information from non-consenting witnesses. And then going to court, obviously the first argument would not be GDPR. It would be standard objections such as relevancy, burden. Then keep in mind that the party resisting discovery has to prove that the GDPR in this case applies and that enforcement is a real possibility. And then the court would weigh the factors and act accordingly. So that's the recent case law. Some ideas on compliance. Caren, over to you.
Thank you so much, Sean, and thank you so much to Sean and Daisy for these really great practical insights relevant to the GDPR and its intersection with the United States discovery obligations. For additional practical guidance on these and related topics, be sure to access the links posted in the resource panel on the left-hand side of your screen. And with that, I'd like to extend my sincere thanks to Sean and Daisy for joining us today and sharing their industry expertise with you. Please leave your browser window open as a survey will appear momentarily. Thank you again, and we wish you all continued health and safety. Have a wonderful afternoon.